welcome everyone, both those that are here in person and a bigger group that is attending remotely today. So I'm Frank Bailey and the president of Pioneer Law Center, we're delighted to offer the first in what I hope are a series of educational programs. This one is on artificial intelligence, and it's really a demonstration. And, you know, I always said in court, never, ever do a demonstration in court, because if it can go wrong, it will go wrong. But I'm taking a leap of faith here. And let me first to you a little about who we are. 2 seconds on that. So we were organized as a public interest law firm affiliated with the Pioneer Institute in 2022. You know, it's already been over 2 years since our launch, and our goals are broadly to enhance liberty and to protect civil rights, in particular in application of constitutional principles. Our focus has been mostly Massachusetts, but our board consists of members from other New England states, and we're expanding that. Hopefully we will cover and have more active litigation in other New England states, Caitlin, thanks. Our focus areas are educational choice, economic opportunity, and government transparency. Let's go on to the next. I'm delighted to talk about some things that have gone our way recently. The first of which is we filed an amicus brief at the state Supreme Court, where there was a challenge to the wording of a petition that is going to be up for vote. We felt that the Attorney General's approach on the petition, both the title and the all-important short statement, which is what most people read before they vote, were properly done, and we were successful in that. My friend Todd Kaplan is sitting here with me today, and Todd was our partner. He's at Greater Boston Legal Services, and I'm delighted to see him. We had a very successful litigation out in Springfield, where we were challenging what we call equity theft. A client of both Todd's and mine was about to lose her home to the city of Springfield, where she owed about $22,000. He'll correct me if I'm wrong on the facts, but about $22,000 in taxes. A home that was worth at least, say, $250,000. And the Springfield was like following the law. You know, they would have been permitted under our state statute to take all of her equity and to take all of the accumulated family wealth that in that home. And Judge Callan stopped that from happening by ruling in our favor that statute was unconstitutional, applying a U.S. Supreme Court opinion on which we also filed an amicus brief with Morgan Lewis. And now I'm happy to report that the state legislature, the House and Senate, have passed legislation that we're quite happy with. And we're waiting for Governor Healy to sign that legislation. And finally, in the Jarkizi case at the U.S. Supreme Court, we filed an amicus brief there as well. That's a case where an individual had been charged with civil penalties by the SEC of $1 million in fee, a sanction of $1 million, and he was banned for life from working in the securities industry. But the trouble less about the situation was that under some relatively new law, new for me, 2010, it was permitted to have that entire adjudication before the SEC itself. all the way up to the point where it would go to the Fifth Circuit. So he had no opportunity to have his case tested before a federal district judge or a magistrate judge. And we felt that was overreaching and unfair. His first level of appeal was to the SEC itself. His first hearing was before an SEC judge. And we just felt that an Article III judge should have a hand in that. And so the Supreme Court agreed with Mr. Cherkesy, agreed with us, and some of the questions from the panel at the Supreme Court that day echoed things that we raised in our brief. So we're making some headway. I'm going to skip what some of these. We will be circulating in the next week the next version of our in-brief newsletter, and our in-brief newsletter will bring you up to speed on some of the things that we're planning to do. But I want to get to this game, and so I'm gonna. And by the way, we'll post the slides, and feel free to go to our website and you can get them. There will be many more. Oh, but back to that last slide though for 1 second. This is how you get me. If you want to reach me, I do answer that phone number right there. And Andrew Horgan is our Chief Development Officer. And so, and I know he answers that phone number. Every development officer answers the phone. So, very good. Let's move forward then with our program. I have with us today, and I'll ask you to say hello so the owl picks them up. I have two college interns, Ryan Frigerio, who is a rising sophomore at Cornell, and Ryan Haddad, who is a rising sophomore, Ryan, yeah, I'm right, at UCal Berkeley. And these guys have been just terrific with us all summer. And I thought the best way to figure out AI is to ask somebody in whatever they call their generation, that goes down past X and past, I don't know what, but I thought, let's see how they can help me understand how AI works, and particularly how it's going to influence our practice of law. And it's going to have a powerful impact. So let's talk more about that. I also have two legal interns this summer, and we'll introduce them a little later, but they of course asked me right away after seeing this presentation, why are we going to law school? Because it looks to us like maybe we'll be displaced by AI. I assure you, we will not be displaced by AI, right? There'll be nothing but more litigation and more deal making coming out of AI. So there'll be plenty to do, but it will have a remarkable impact. As I said before we started, we were going to do a demonstration. I always said and warned lawyers who came to my courtroom and said, we'd like to do a demonstration. I've always said, don't do that. It's going to go wrong. But we've practiced this, and I'm pretty sure we'll get it right. So there's a little bit of risk. So a little background on AI and the legal scene. We all know ChatGPT. ChatGPT, is really the front runner, and got a lot of news earlier this year and the end of last year concerning the development of its AI function. And the entity is something other than ChatGPT, but that's their software. I've been quoting Bill Gates about AI, something that he said, I think, about Microsoft Word many years ago, that we always overstate the influence that tech change will have over the next 2 years, and we understate the impact that tech change will have over the next 10. And I really do think that's what we're going to see here. Everybody's up in arms about what's AI going to mean for the legal profession, and it's going to change everything in the next 3, 6, 9 months or 12 months. Probably not. Is it going to change the entire world in 10 years? Most definitely. As we incorporate it in our practices. So definitionally, AI is actually nothing new. When you start writing a sentence and some of your software programs, finish that sentence or suggest a word, that's some level of AI. We're talking about generative AI here, and generative AI is more of what you might say is not completely simply machine learning, but it replicates human intelligence. Now, how that happens, you are not going to learn today because we don't have anybody here who could possibly explain that. But it's not necessary for what we're trying to do today. But just remember, generative AI is a subset of AI. How quickly is generative AI changing? It's remarkable, really, how quickly it's changing. Let me give you some stats on things that we found the impact. The first of which is that the ChatGPT had its took the LSAT, the law school admissions test, with ChatGPT 3.5, which would have been last year, 2023. When it took the LSAT, it scored 148. That's in the 37th percentile. That might get you into law school, but not many. In just a few months later, at early this year, with 4.0, it took the LSAT again and it scored 157. That's the 70th percentile. That would not get you into Boston University School of Law. It would not get you probably into Boston College School of Law to look at the locals. It definitely wouldn't get you into Harvard, but it would get you into plenty of perfectly good ABA approved law schools. And then most recently, it took the LSAT again and it got a 163, which is 89 percentile, almost the 90th percentile. That's starting to get you into BU. It's starting to, I think, am I right?
I think you maybe need
A few more
a
points.
few more points, but it's
Okay.
top 30, top 40 for sure.
Top 30, top 40 law schools. So here we are in July. My guess is that by the time the fall comes, ChatGPT is going to get into Harvard after all. So
Is it learning the questions though?
how is it accomplishing
I
that?
mean, is it learning the questions rather than just better at asking them?
That's a good question. It's probably beyond what I could tell you. I had some other statistics, but I think I'll move past them. I know that for one of the things that seemed to impress our students the other day is that a lot of maybe your children or grandchildren, are taking the AP exams, that kind of thing. It regularly now gets a 5, the highest grade on AP exams. It seems to do a little worse on the language-based things, like the English composition APs. It does really well in math and science, and it regularly gets 5s with those AP exams. It does very well on the non-verbal part of the SAT. It's regularly scoring in the top 10% of students. So it's doing that well. So our purpose today is to create some documents, and it'll be mostly in the litigation setting on how lawyers might use, or laymen frankly might use. We'll use ChatGPT and we'll generate some litigation documents, but you could certainly also use, and I guess we will demonstrate how we can develop contract clauses as well. One thing we won't be doing with it today, but I really wanted to mention is something that the firm of Sullivan and Cromwell have become a bit famous for. They have developed a tool that where you load all of the information in a litigation. So all the deposition transcripts, all the documents, background information that you might have learned, all into a platform. And then literally while a deposition is going on, it will test the answers by the deponent against that database and suggest questions to the questioner so that you can actually ask questions. And if you choose to cross-examine the witness at that deposition, you will have the raw materials to do it. This could be used at trial as well. And so this information will all be there. And rather than have what we always had, which is your trustee, first and second and third year associate sitting next to you, handing you notes, saying, I memorized the entire transcript of this guy's deposition and he just said something that varies it. This is going to give you that and more. It'll look at a database of all the documents. It'll spit out proposed questions for you. Those of us who have tried cases will tell you this is a remarkable tool. Sullivan Cromwell and a few other large firms have developed their own software programs on this, but are making it available. I think all litigation firms are going to have this technology in the next few years. Ethical concerns. We all are familiar with this New York lawyer that became quite famous because he apparently did a submission to a court, and when he did the submission, he generated the submission by using ChatGPT or another AI platform. It literally made up cases. Smith versus Jones, 123 New York Supplement, 123, 1989. Case didn't exist. Well, he made the biggest mistake of all. He didn't bother to go read that case because he would have found it didn't exist. And when the judge caught him in this, he was sanctioned, and he was also sanctioned by the court, but also sanctioned by the New York licensing authorities. Well, that got a lot of press, and I think it scared off a lot of lawyers. We're a scary bunch. We're a scared bunch, right? We don't move quickly to new technologies. It took me a long time to decide that I could trust Westlaw. Now everybody's room will laugh, right? Because it's the only way we find cases. But the situation as it existed with that lawyer, I think has made lawyers a bit more reticent to moving toward AI as an additional tool. What has that also done? That scenario has also caused, and I was on the bench 2 years ago when this was happening, we were hearing a lot about maybe adopting session rules for your court or local rules for, I was bankruptcy. So in our bankruptcy court, banning the use of AI by lawyers or making them disclose that I've generated this document using AI. I felt then and I feel now it's a bad idea. It isn't the AI that's the problem. It's the lawyer that's the problem, right? So, and we're going to see that right now. I think you might agree with me after you see what we've cooked up. So AI is a tool, and just like we use Westlaw to check cases, to find cases, we are going to use AI to help us be better lawyers. And so that's the good news. I got it wrong. ChatGPT in its most recent LSAT got between a 163 and a 180. So 180 would get you there.
Harvard, yeah.
All right, it just got into Harvard. Okay, so let's go ahead and do this, Ryan. And by the way, both of my colleagues here from Cornell and Berkeley are named Ryan, so that makes it easy for me. Ryan Frigerio, we have created a scenario. I'll have to remember it because I can't see it, it's too far away, but what I remember about this scenario is a very typical business litigation problem, and it goes like this. We'll call it Ryan Frigerio, how's that? And so Ryan is an IT specialist, thank you, at working for Pioneer Legal. And on June 30th, before he joins in 2023, before he starts working, Ryan signed a non-compete agreement with Pioneer Legal. And the clause stated that he was prohibited from competing with Pioneer Legal for 15 years in New England, in all of New England, right? Many of us in the room where the lawyers are saying, whoa, that's too much, but let's find out. But that's the scenario, and that's what he was done on. I mean, that's what he signed. However, almost immediately, just 3 months in, he comes into my office and Ryan says, I'm gonna hand in my notice today. I'm leaving, and I find out very quickly he's going to work for New England Legal Foundation, where my dear friend Dale Winslow is running the shop, and we are dear friends, former law, but we've worked together. And we do have some areas of competition though between Pioneer Legal and Pioneer and New England Legal Foundation. And so Ryan and their offices, downtown Boston, quite nearby. And during his time at Pioneer Legal, it turns out Ryan had access to confidential information. And upon inspection, our IT specialist tells me that he downloaded Pioneer's client list, which frankly wouldn't be much, but downloaded our client list just prior to leaving. And that the non-compete clause, it looks to me like it was violated. So we're going to put in a prompt. And if I turn this over to non-lawyers, so Ryan, why don't you tell everyone what your prompt is to ChatGPT? What do we want ChatGPT to do?
Can I just ask though, wouldn't
Yeah.
the non-compete have been violated even if you hadn't downloaded the client list?
That's a separate tort. Yes, in all likelihood, yes. But
Yeah, so right here, we've asked ChatGPT to write Pioneer Legal's complaint seeking an injunction and monetary damages against Ryan and Nell.
and let me emphasize, what you're about to see is ChatGPT do its work. This is a demonstration. This is something that Ryan's going to enter. I hope it works, but let's try. And I hope you can see it.
Yeah.
It is generating a complaint because that's what Ryan asked it to do. It's done.
Are you able to see it well now?
I can't, but we'll have it finish and then.
Control plus or something.
That's bigger.
Yes.
So I'm not gonna walk you through every bit of this complaint, but I think. Those of us who have practiced law in the federal district court, right? Sarah?
That's terrific.
It's terrific. This is a very serviceable complaint. Now, I'm not like the guy in New York that I would sign this and file it. I might just read it. But it's got the right caption. It sues Pioneer Legal against both Ryan and Nelf. It has a little introduction, and it describes in the introduction what we're trying to do. It describes the parties. I think we put Ryan in New Hampshire, did we?
We put Massachusetts for this.
For both, okay, so we
Yeah,
won't get into jurisdiction, but it found that there is proper jurisdiction. And it even found venue is proper in Massachusetts. It then lays out all of the facts.
that's interesting between citizens of different states. I think that.
That's probably not right, so I might catch that. We don't know.
Which thing,
So what might be wrong is if we put when we're trying to get diversity jurisdiction, that would mean that, that they would need to be from different states,
It's not-
and they're,
Not clear that.
we haven't given it a fact. I don't know that we gave it Ryan's address.
Yeah.
We haven't necessarily told them that Pioneer Legal is a Massachusetts, LLC either.
Yeah.
So it doesn't have all the information it needs. So human error is really what we have here. But then we go down to, the counts. It's properly alleges a breach of contract because Ryan breached, as was pointed out here, breached the non-compete just by going to work. Now, where that goes, I don't know yet, but that's certainly the right thing to say about it. And then misappropriation of trade secrets is against Ryan. That's a separate tort. Because he took our confidential information and then tortious interference against NELF because we had enough information to say that NELF, he was bringing that information to NELF. That might be a little slim, but that's what we have said. Prayers for relief, what does it ask for? It's asked for a preliminary and permanent injunction. I think I'd ask for it that way. And they would ask for an award of damages in the amount to be determined after trial, because we know what those are, against each of the defendants. And ask for punitive damages, and some of us from Massachusetts would say probably not gonna get that. It even thinks to demand a jury trial, and since Ryan was such a bad guy, I'm happy to have a jury in this one. Okay, so I think we can do this. Does anybody in the room or anybody want to react to this? Sarah, does this look, not to put you on the spot, but it looks pretty good, doesn't it?
It looks like a great first draft. I mean, and it was typed in 30 seconds. You could see
At
it
most,
taking
yeah.
a lawyer 45 minutes to pull it all together. Now, a lawyer might analyze the jurisdictional issues and some of the other things that would slow down the drafting, but as a shell, I think it's a great start.
What if you gave it to a first or second year associate? Is that 45 minutes?
To draft,
Draft that?
to draft that. At least,
Oh, I would say,
Yeah.
I'm guessing a lot more, but.
Yeah.
Maybe you have better first year associates than I did, but anyway,
So I'm not a lawyer,
yeah,
but I was a journalist and.
Yeah.
Wouldn't you have taken a case like this that you filed 6 months ago or a year ago? Taken the draft of that to start with and filled in blanks and replaced things
Absolutely.
in there? So you wouldn't have started from scratch on this
Let me
yourself.
just point out, yes, if you had it,
that's right.
but there's sometimes you're in areas where it's like completely new territory for you. So you don't have any
Well,
thing to cheat
right,
off of.
right.
That's exactly right. This one would be easy, given my background. I probably knew all of this. I know enough to say that I think it hit all of everything, but. Anyway, we're gonna move on and what are we gonna
Yeah, we're
generate?
moving into discovery now.
For what it's worth,
Yeah.
I, early on with an early version of ChatGPT, I had it generate a trademark infringement letter. And I had very similar results. It was a good, workable, serviceable draft that, a first year, second year associate could have come up with. And
And that's a while
a
ago.
good starting point. Yeah, that was, I think, with ChatGPT 2, but I could be
Oh.
misremembering, so
Right,
it was a while ago.
so that would be way better today,
Yeah.
right? I mean, I don't know if it could be better, but I'm just saying.
It was a perfectly fine,
Serviceable
starting
start,
point.
yeah, yeah.
Not something where you'd say, oh, this is the best writing I've ever seen,
right,
but you could start from it.
right. All right, Ryan, what do you want to try next?
Yeah, so we're gonna move into discovery now and do some interrogatories.
Okay,
Um,
so let's draft some interrogatories. Sorry,
30 minutes.
okay, we gotta move faster, yeah.
Sorry.
No, it's my doing. And your query is ask Pioneer Legal, write Pioneer Legal's interrogatories directed at Ryan and Nelf. Interrogatories, of course, for any non-lawyers these are the written questions that the rules allow one party to ask another party. Right off the bat, I see it's doing definitions. That's a state of the art, I would say. So you don't have to repeat all those words. And then it lays out a number of topics. Looks like it's gonna be 8 to Ryan, and now it's doing interrogatories to Now, if we asked it to put them all in one document, I wouldn't have done that, but I would separate these into 2 documents. It even knows to ask for a certification and okay. If we look at some of these, we'll see that it asks questions that you would no doubt want to know, right? So tell me in number 2, describe in detail all the actions you took to seek employment with NELF, including but not limited to the dates and any communications you had with NELF or its representatives. Go on down to NELF. So we'll keep moving, but and I can tell you, we'll post these results. But and by the way, tell Dan this is completely fun. Ryan never left us, so we asked NELF to describe Ryan's job responsibilities. We asked whether he has discussed or given you any confidential information. These are adequately broad. Again, no doubt I would come up with some other topics. We usually would. I think the number that could be asked is about 30. There's no need to ask 30, but we would have some more room to delve into more interrogatory questions. So let's keep moving.
Sounds good.
Unless anybody wants to comment.
I was just gonna say that
Yeah.
it's also like very customizable, so if there was like a certain thing that you wanted to ask about or like types of diction that you wanted to use, you can say ChatGPT, here's something that I've written in the past, can you mimic this writing style and write it like this? And that can be applied to this as well.
So you could add to your query and get a more detailed.
Or even on the other end, ask it for more of like a
Ah.
template kind of thing, and then fill in the blanks like on your own outside of it.
I see. Yep.
Yeah, and that's how a real lawyer would generate interrogatories. You'd say to your associate, here are my definitions and the key questions I always ask. Start with that as your base.
That's right. That's right. So again, I think it's given us a serviceable first draft, decent format. I had read those earlier, and I can tell you, I probably would have asked every one of those, there's probably another 5 that I could come up with. Okay,
But
Right.
you said, you said writing style. Now, what would you do? Put in something you'd written, a long thing you'd written and send it to ChatGPT and then say
So-
revise yours?
The thing that ChatGPT for, it like learns from itself in the same kind of like chat. So in theory, you could put in something you've written like in a certain, in like your writing, and you can say, try to mimic the way that I wrote this in that way. And it can do it pretty.
You mean you put in another set of interrogatories from some other case?
Yeah, or something similar that yeah, because you know how it kind of the way they ask them exactly like the diction, you could customize it based off of how you like it.
But then you're putting your confidential information out into ChatGPT, which is
That is
probably
Also,
of concern.
yes.
that's definitely something to talk about, right? That is an issue. But let's go on to another document.
Yeah, so now we just have Ryan Berger's responses to the interrogatories. And so here we'll see that ChatGPT makes up a lot more information.
Right, this is interesting, yeah. But here it is generating. So it literally is making up responses from the facts we gave it, but where it intuits that there are other facts that would normally be the case, it's including those. Now we're in a dangerous area, right? Because it is literally making up some facts here that don't, that we haven't given it. And that's why I say we're in a dangerous area.
So it's fiction.
It's at this point, it's fiction based on likelihood, right? Presumably it is examined, as the enormous database, the internet, for what in these kinds of cases would normally have happened, and it's filling in. Fiction is a fair way to say it for this case, right? This this might give you something to ask your client about, right? It might give you something to have a discussion about. But I think the lawyers in the room will agree with me, we're a little bit on dangerous ground here, right? Because it's making up facts. It could well be that those facts existed, but we don't know that. We haven't told ChatGPT that that's the case.
It may not give you the same answer if you ask the same thing twice.
Yeah,
Which is
fair enough.
another
We
thing
did
we're-
that.
Yeah.
Yeah, that's exactly right. Mhm.
I was gonna say, to get back to your original question, is whether this can put lawyers out of business. It might not necessarily put lawyers out of business, but it may fill a gap where people are struggling to understand all of this legalese. And they say, well, what's interrogatory? How do I answer interrogatory? Or whatever, and there could be functions where the question, you read ChatGPT reads the question to you and then prompts you to answer. Like,
Right.
or you answer it the best way you can, and it turns it into a answer that's acceptable
So-
or responsive.
And Todd, on that,
Yeah.
I think, yeah, where you work in the legal services field and, there's always a lot more work out there than you guys can even take in that you could possibly do. Does this offer an opportunity, do you think, to help pro se's?
I had a guy yesterday, I said, I'm sorry, we can't cover every case in every court, and all he wanted to do was an answer.
Yeah. Mhm.
And that would have been this, I'm not sure how, I think the problem is like how, this accuracy piece, like
Mhm.
testing it or figuring out, how much is it making up and how much is it reflecting what you say?
Yeah,
But there definitely could be tools that are created that are, advanced enough that could help people just even do an answer or counterclaims or jury demand.
But if it's making up even one fact out of 150,
Mhm.
that's a big problem.
it's a big problem. Yeah, I mean, I agree with that. And a non-lawyer might miss that, right? A lawyer might miss it, but a non-lawyer could easily miss it, So one idea that comes to my mind is that where legal services, can't cover the full field, but you're trying to level the playing field a little bit. Have the litigant, the pro se, unrepresented person disclose that they use ChatGPT in formulating this response. And then, maybe then it's up to the court to be a little more discerning about this.
Yeah, but you were against disclosure.
That
Sorry?
You told us earlier. you
was
were
for
against
lawyers.
disclosure.
Yeah, I am against disclosure for lawyers. I'm against requiring disclosure for lawyers. I think that non-lawyers, maybe it's a way to bridge this gap.
But as a judge, I'm sure you are confronted with people who are pro se,
Oh,
and
yeah.
just like, all I need you to do is file something
that's right.
that's responsive to this motion. Otherwise, I don't have anything before me.
I'm so glad you said that, Todd, because that's exactly the speech, and they wouldn't know how to even do that, right? And if they had a really simple in the clerk's office computer, that gave them access to, maybe it's a few years away, maybe it's a year away, that gave them the opportunity, to at least generate a response. And it discloses to the court, and they could put in the facts. It could ask 5 simple questions. And then generate it in a way that looks something like we would understand. That might just be a very useful tool.
I don't understand how a judge could rely on it if someone hadn't gone through it and troubleshot it.
No, but first of all, if they don't file anything, game over.
Right.
Right? Second, have them in and ask them, you filed this answer. Let me go through it with you. take your time and go through it. Otherwise, there's access to justice problem, and that happens every day in our system. Okay, let's move on to the next one. Those are good questions, though. Thank you for raising them. I think we're right. Yeah, okay, our next. You know what, we're gonna skip this.
Even with the cases that it produces and stuff.
Yeah, well, go ahead and put it in. So what, we won't have time to spend on this, but we're gonna have both defendants move to dismiss this complaint. And let's just see what their memorandum of law looks like. And Ryan is right. The most impressive part about this to me is it cites all the right cases. It really does a pretty credible job. The leading case on jurisdiction, leading case on, what we call 12B6, is, have you stated a cause of action? The standard is Iqbal and Twombly. It found them, it cited them. That's all appropriate. When you get into the scope of a non-compete clause, now we're applying Massachusetts law, and it's a cite to, we've checked the Dunkin' Donuts case. These are the right cases. Anyway, we are this again, you can't sign this and file it, but it's a quite credible job. And
It's not long enough, is it?
that's a really good point. You know what?
I've never
You know
seen
what?
anything
I
else
could
short.
still make it shorter, and I think it'd be better if it were shorter, but.
The problem with motion to dismiss, it's simple to do it, then you have, the response is a lot of work.
That's right, yeah. So let's keep moving though, because
Sounds
I
good.
want to get to the
So right
end.
now we just have the non-compete clause.
We're gonna
that's it.
skip that.
Okay.
The next thing that we would have it do is draft non-compete clauses. Or a non-compete clause that might, from the beginning, have actually done a better job. And if we say apply Massachusetts law, it's not gonna give us 15 years. It's not gonna give us all of New England, right? It might give us inside Route 128 and for 18 months or something like that, So it's smart enough to know what the scope of that should be. What was our next demo? It was,
Fake evidence.
okay, this is what I really wanted to get to today. This is my favorite part. We hear a lot about fake evidence, right? The word fake never meant much to me until about 2016, and fake has been a very important word in our lexicon since then. And there's a lot of talk about fake evidence. When I was still on the bench, I had a demonstration by Adobe for judges, and there's a free software program that they offer. Adobe knows that using Photoshop, which is a very important platform for them, that you can put people in images in places where they never were, and it'll look like they were standing out in front of the house that day. It'll put them in the crowd where the demonstration was occurring. It'll Photoshop people into spots, right? So Adobe, knowing that judges could be faced with, and litigants, lawyers could be faced with fake images, they have made free software available where you apply that software to the image, and it will tell you whether or not it's had Photoshop applied to it, and it'll give you each generation back to what it originally looked like. Again, it's free, and it's just a credibility situation. I left the bench, but I was already thinking about maybe I needed a local rule saying that when you submit photographic evidence or video evidence, that you have applied this, certify that you have applied this functionality to the image, so that I know it appears to be genuine, right? I don't know that anybody's done that yet, but I know Adobe is hot on the trail of doing it. But we decided that we wanted to come up with some fake evidence. And what would be better than having a former president tout Ryan's move? And now we'll see with that buildup, Ryan, can we demonstrate some evidence that you might, now, I'm not saying this would be admitted, but I'm saying maybe it might be offered. Go ahead.
Sure. So the point of showing this is, as Judge Bailey mentioned, that fake evidence has lots of future potential implications on law. And the reason why we're going to show this video is because it displays both photo and audio qualities of AI. So you can take from this, what if someone in the future records a phone call that never happened and it's used as evidence, or what if someone has a photo that was used? This is a way to show perhaps both. And this is simply just an AI website that I was able to find online. I paid $7 for this membership, but I could have done it for free and it would have been a little bit less quality. But we can just hear what Donald Trump has to say about this case.
Congratulations to Ryan on his move from Pioneer to NELF. I've always thought NELF is a much better organization, and you'll make a lot more money.
It needs a little bit of work. I mean,
This is a $7 version.
Yeah, thank you, Todd. This is the $7 version, but you can imagine that, yeah, for maybe $50 or maybe in 6 months, that's gonna be a lot more seamless. And by the way, the audio isn't too bad. We ran it kind of fast, if you ran it slower, I think it might sound better. The image doesn't line up well, with it.
So I was gonna say that actually I've been very concerned about this in my work at legal services. Because one of the things that happens is that you're have to react quickly to some
Yeah.
crisis. That someone's like, my landlord's throwing me out today. And you're presented with evidence, you don't have really good opportunity to review it or figure out if it's what's going on. And you run into court and you say, hey, judge, look at this. This is really terrible. So and it'll be a fake.
Yeah.
It will be a fake. And it'll be somebody fabricating evidence, and you've been duped. So one of the things that I've been thinking about is offering a award, might not be much, maybe $5,000. The first deep fake that someone actually uses in court, that and we might be able to anonymously so that people don't get too embarrassed. But it is a true hazard.
Yeah.
And it's getting worse.
Right.
You'd offer an award for somebody who got caught or somebody who didn't get caught.
I think we want to get somebody who got duped. I think it's more like they got duped by somebody and then they discovered it was fake.
Well, if they dupe a judge, they're gonna get more than a $5,000 problem on their hands, is my guess.
Yeah, no, it's more to get people to thinking about it and being on guard. I think that was our point.
Right. So, there are two more things I'd like to raise, and one is I'll turn to Emma, because Emma is a rising 2L at BU Law School. And I'm wondering what in law school, and you're perfect to do this because you just went through first year and your first year writing program and you're getting the skills that are going to be with you for a while. How are they dealing with AI in your generation of submissions and on exams and papers and all that sort of thing?
Right, so all first years, I think across all law schools, take a lawyering class. So this is where we get all of our practical skills. And VU has specifically added an AI unit in which we used Chat GPT, Lexis AI, and Westlaw AI, which for people who aren't lawyers, Westlaw and Lexis are databases. I do everything on Lexis and Westlaw to get cases. And I did this prompt in Westlaw and it was horrible compared to ChatGPT. So we are being taught how to use it. However, if we're not using it in these dedicated units, things like that, then we are subject to the disciplinary action because it could be considered a form of plagiarism. So we have to be careful of that. So it's presented to us as an option. And other than that, it's kind of a no-go for law students.
are they teaching you at all about the ethical issues of, you know, lawyers are subject to so much confidentiality? And my general understanding is whatever you load into chat GPT, it then uses it, right? And you're not supposed to put your client's confidential information out into the universe.
I haven't taken professional responsibility or evidence yet, so I am almost certain that will come up there. We only ever talked about it in the lawyering class as generative. And kind of decided that you have to check everything, but that never came up.
If you have an enterprise agreement with ChatGPT, they do say that they keep your information, your submissions confidential. Whether you can rely on that as a lawyer is a different question, but at least as a matter of contract, they promise confidentiality.
I don't know if that would pass the
Don't disagree with you.
good practice standard.
And Westlaw has some, at least the way they pitched it, is that they're using everything of yours, your entire ecosystem. They're using your prior drafts, memos, everything. They're using it to work off those things. And they're promising that they're using it within your ecosystem, that they're not exporting it. I don't know how they do that, but that's what they're promising. And then the other thing that's Westlaw is promising, as opposed to ChatGPT, is that the ecosystem is closed. So it's not an open system. They know what's in the box that they're sourcing as for cases, et cetera. And so that they're hoping to eliminate the fictitious and ghost cases and stuff like that by having a closed system.
But they're obviously taking things from outside that closed system, or they wouldn't be able to produce anything.
No, they're using the legal, in some ways, the legal system is a closed system. Unless you're doing something that's a policy argument or something that's a creative argument, but you are kind of within a closed system of a world, so to speak, of cases and law.
I can speak a little bit to your question about the confidentiality aspect. As Nathan was speaking about earlier on ChatGPT 4, if you type within the same chat, it kind of remembers what you said prior. But what we did actually was to try to test that confidentiality aspect, in that we put in all these prompts, and then it came out with all the legal documents. But then in a separate chat, we asked, is Pioneer Legal perhaps filing any sort of lawsuit against NELF? And it said no. And I think one thing that's important to note is that the way that these generative AI platforms work is it's essentially just collecting data, and then you can think of it as upvoting the data or downvoting the data. If someone else puts in a similar thing into ChatGPT, it counts it as, oh, we are validating this claim a little bit more because one more person has done it. But there's so many people using ChatGPT every single day that one person putting into their own ChatGPT prompt is not going to affect any future prompts or answers that you might get, as much as if 1,000 people were to type in the same exact thing and see what ChatGPT would do with it.
Which answers the question to some degree, Sarah, but not adequately for me, right? Because all that says is that it didn't happen to notice that we've been fooling around for the last 2 weeks with putting in those names and a possible lawsuit, right? It didn't notice that, but it could have. And so the confidential information is still in there, so if this were to have been disclosed and it were to have adverse impact on if you're Pioneer Legal's lawyer and NELF sues Pioneer Legal first for some reason, because they caught wind of this on ChatGPT, that could be a negative for Pioneer Legal and maybe malpractice on the part of the lawyer, right? Or maybe worse.
Insider trading, if you're doing a deal,
Oh, yeah.
if you're at Sullivan and Cromwell.
Exactly. That's right.
Well, I was wondering if the volume of queries related to a specific subject would also affect it. For example, how many people are today drafting complaints about this latest crash of all the computer systems?
Right.
Thousands,
Yeah.
including lots of people who are using ChatGPT could be doing their own pro se complaints.
No doubt. Ryan had the question that I also asked you to look at, is, are there any functions out there where you can, a software capability of determining whether something was generated by AI as opposed to human drafting. Do those things exist yet?
Yes, those platforms exist online, many of which are free, and I didn't even need to sign up for any kind of service to log into most of them. But I tested out 4 different sites. I didn't use these legal documents. I instead used a memo that I wrote this summer,
For us.
but I'm not including it right now because it's just confidentiality reasons. But
See, I trained them.
yeah. So 3 out of the 4 said that my writing, which I completely wrote myself, was 100% human wrote. But 1 out of the 4, the last one, said that there was a 40% chance only that it was wrote by a human and a 60% chance that it was written by AI. So what that shows us is that, you know, it's not perfect, although 3 of the 4 actually were correct. So that's a good sign that it's somewhat reliable and it will probably continue to get more reliable, but it's not perfect yet. I think the way that I like to think about this kind of detector system is kind of like a spam email detector. I took a class this past semester that focused a little bit on that, but essentially what these detectors are doing are just picking out certain clues or patterns that it notices within different AI prompt or AI responses that it was trained on. So the platform is trained and then it's tested, right? And so we are testing it. So I like to use the spam email example as a way to say that these detectors are looking for certain clues, you know, maybe ChatGPT has certain phrases that it likes to use, maybe it has certain sentence structures that it likes to use. And then essentially by adding all those different red flags up, it has a threshold. And if you're above that threshold, it says it's, you know, AI generated perhaps. And if you're below that threshold, it says it's human generated, something like that.
Dot.
I was gonna say, one of my biggest concerns is the, I guess I would call the strategic disadvantage that I have to not having some tools. For example, you know, I'm at legal aid, we don't have a limited amount of money. When I've asked Westlaw for their most advanced products, they said, we cannot afford to give it to you because this is very expensive product because of the amount of computing power that we're having to devote to it. It's in there right now, it is expensive. It requires huge, I mean, there's towns that are, all of their energy is used up on AI computers. But there are some things like you kind of mentioned, you're middle of a trial and you want to be listening to everything that witness is saying and digesting it and, you know, or you're in the middle of a deposition and you want to be, you know, you're only human and everybody can only remember so much, but the AI could probably remember everything and bring everything to the table, like, oh, what about this question? Or, you know, or someone throws a case at you that you didn't know existed.
Right.
And you wanna tell me everything about this case. Well, that's bogus. That's a 128 decision. That's not even binding, you know, whatever. Instantly, well, I may not have that tool, someone else on the other table has that tool.
Well, the way that a lot of these platforms work is by offering a free service and a premium service. So although you might not be able to pay for the premium service, which comes with a couple extra services, many of these platforms have a free service.
It's nice to know, Ryan, but the reality is what Todd is saying is you gotta level the playing field, and as soon as somebody else has a premium, something that you don't have,
Of course.
you know, in the heat of battle, you know, this could be a real unfairness.
The
You know?
playing field in life is not level.
Yeah.
If you can't afford it, you can't have it.
Resources are expensive, that's true, and so I think we're really where we need to finish. Thanks, everybody, for joining today. I'm gonna ask Andrew Horgan, who's our Chief Development Officer, to come on for a second, but just before that, Andrew, I want to say thank you to Ryan and Nathan and Emma, our intern, to really with this program for us. And I learned a tremendous amount And I'm glad I'm gonna be practicing law when they are in 25 years, because I don't know what it's gonna look like at all. So anyway, Andrew.
Thank you, Frank. And just to echo your comments, that was a fascinating presentation and great opportunity for for me to learn a lot more as well. Yeah, as Frank shared at the beginning of the presentation today, the Law Center is continuing to have a tremendous amount of impact and wins, especially over the last couple of months. And the reality is that as the Law Center is becoming more well-known and being more impactful, Frank and the team are getting more calls. And the challenge with that is that it's a small team. We've been relying on creative partnerships with outside law firms, obviously our interns, and that sort of thing. But at the end of the day, we're having to turn away more and more people that are reaching out for help. And as Frank so aptly noted, resources are expensive. And for us, the key to having any of these resources is philanthropic support. And what we're really trying to focus on in the coming months is to bring on another attorney, paralegal help, to really help dramatically increase the capacity to help those in need. So for anybody who's open to having that conversation, I'd welcome the opportunity to do that. But we also want to get a date on your calendar, and that is Thursday, October 17th, when we are going to be hosting the Law Center's inaugural Dennison Lecture, which is named in honor of our founding chairman, Brackett Dennison. And this year, our speaker is going to feature Paul Clement, who is the 43rd U.S. Solicitor General and has argued more than 100 cases in front of the Supreme Court. And we'll be tackling an issue that certainly resonates with all of us, given how things have gone over the past year, and that is free speech and First Amendment rights on college campuses. So we hope that you'll be able to join us on the 17th of October. More information will be coming out. If you'd like to register, sponsor a table, get any of your firms involved, we'd love to have that opportunity to partner. And again, thank you all for joining us today, and kudos, Frank, to you and the team for really doing incredible work in such a short amount of time. So with that, Frank, I don't know if there's anything else you want to close on, but again, just want to express my gratitude for everybody joining.